Hello and welcome everyone to FSB's webinar, The Employment Rights Bill, Phase 1, April 2026. My name is Emma Smales and I am pleased to welcome you this morning. The webinar will focus on proposed upcoming changes in April for employers under Phase 1 of the Employment Rights Bill, including changes to statutory sick pay, managing absence effectively, and the Fair Work Agency. Before we get started, this webinar is for employers in England, Scotland and Wales. For any employers joining from Northern Ireland, here employment law is devolved from Westminster and is handled at Stormont, currently governed by a four-party mandatory coalition in which Sinn Féin hold the Economy Department and responsibility for employment legislation. The Northern Ireland Economy Minister brought forward proposals in 2024 for an overhaul of 17 separate areas of employment law. The FSB Northern Ireland team has been engaging extensively with members as well as with the Minister and officials and is now awaiting publication of the final bill, which will be subject to consultation. Given the widespread concerns, it's far from clear if this bill will become law before the elections in spring 27. So if you are an employer in Northern Ireland and wish to engage in this work, please reach out to FSB's Northern Ireland team via our website. But back to the Employment Rights Bill Phase 1 and April 2026. Today, I am joined by Hannah Thomas, Employment Law Solicitor at Markel Law. FSB is partnered with Markel Law to provide FSB members with legal and tax services, and also Chris Russell, our Senior Policy Manager at the Federation of Small Businesses. Please post your questions in the Q&A function on the webinar, where we and our back office team will be able to see them. After our presentation, we will aim to get through as many themes as possible. So let's get started. Firstly, I am absolutely delighted to welcome Chris Russell, who will outline FSB's work in this area. Chris is a Senior Policy Manager at our Westminster team, having worked for FSB for 4 years. His background is in skills and employment, spanning a 15-year career. Chris has been integral to our policy work across these areas, including our work on the National Living Wage, National Insurance contributions, and most recently, the Employment Rights Bill. Welcome, Chris.
Hi, Emma, and thanks a lot for the introduction. I've just prepared a few slides, which I will talk through. Just going to share my screen now. Fantastic. So, as Emma mentioned, I work in our Westminster team, which is FSB's sort of campaigning office. So we engage with government on a whole range of policy issues, but I'm responsible for employment policy issues. And I guess the point of my presentation today is really to outline the very hard work FSB has been doing on behalf of our members and all small businesses on the Employment Rights Bill. I should say Employment Rights Act. It's got its royal assent in December. And yeah, so I just wanted to go through Labour's manifestos and sort of the context which we're operating in, then go back through our feedback we received from our members about the Employment Rights Bill, and just a very brief overview of all the work the Westminster team is doing on your behalf. Really want to emphasise that we know there's a lot of concern out there about the measures in the bill, in the Act, in the wider package, and we're not, we've been very actively campaigning on your behalf, and in December got a very big concession from the government on unfair dismissal, which was a result of lots of hard work from myself and colleagues. So just to set the context, as you know, Labour won the general election in summer 2024 with a manifesto that promised to introduce Labour's plan to make work pay, which had 70 different measures, and they said they would introduce legislation in the first 100 days of government. They included that quote within the manifesto itself, so stuff on zero hours contracts, ending fire and rehire, day one rights for parental leave, sick pay, and protection from unfair dismissal. And in autumn 2024, they introduced the Employment Rights Bill, which contains 28 measures within that Make Work Pay plan. So there's clearly quite a few other measures which they are thinking about at the moment, introducing beyond what's included in the bill. The bill gained royal assent in December, and really important to emphasise, and I think you'll hear this a lot from us today, that not all of the measures in the bill will be introduced straight away or at one go. They will be implemented in a staged approach. So this slide highlights some of the main measures in the Employment Rights Act. I'm going to leave it to Hannah to talk through these in more detail, but just to give you an idea of what is included within the legislation. So the main thing we were concerned about was when the bill was first introduced, they said there was a day one right to protection from unfair dismissal for employees. After lots of campaigning, we got this down to a 6-month qualifying period instead of the current 2 years. Now, we recognise that's not perfect, but we feel like it was a lot better than when the bill was introduced. They also, one of the other top concerns for our members is around the 0 hours contracts measures. Now, they keep saying they're going to ban exploitative 0 hours contracts. What they really mean by that is they are going to introduce rights to guaranteed hours after someone's been on a 0 hours contract for a certain amount of time, reasonable notice of shifts, and payment for short notice cancellation of shifts. The other thing which Hannah is going to cover in a lot more detail is around statutory sick pay, and these changes will be made in April. There's a bunch of other changes as well, which I don't think I've got time to go through in detail. So when the bill was first introduced, we did a survey of our members, which back in November 2024. As you can see, the top concern was around the changes to unfair dismissal, making it a day one right for employees, where 3/4 of small businesses who said that was a concern to them. This is closely followed by statutory sick pay being payable from first day of absence. And these two have really been a lot of our focus so far. And I think on the 0 hours contracts, while this looks less, the percentages are obviously lower than the top two. When you filter it for just those businesses that currently employ people on 0 hours contracts, it's obviously a lot higher. I think these figures go up to sort of 60, 70%. And then about 2/3 of people who responded to the survey said that just the sheer number of changes being proposed to employment law was causing them concern. We also asked what their likely response would be to the introduction of the bill. As you see, 2/3 said they would recruit fewer staff, and over half said they would reduce their investment plans. And also, there's a bunch of other pretty scary stats there. I must really emphasize that these stats are really, really helpful for us, and it really helps when members respond to our surveys. We repeated that 67% stat so many times in the media and in meetings to government officials and ministers, and it helps so much having these stats. So thanks for those who responded to that survey, and if you didn't, please do respond to our other surveys because they help so much with our lobbying activity. So just a very brief overview of our work on the bill. I recognise the government's sort of U-turning quite a bit at the moment, but I believe this U-turn is the only thing they've done a U-turn on, which was actually a manifesto commitment. So they put it in the manifesto that there would be a day one right to protection from unfair dismissal, and they have changed their mind on that. So as I keep saying, this was due to a lot of colleagues' hard work, and we had so many meetings with ministers and special advisors, MPs, members of House of Lords, civil servants, spoke at so many different events and webinars, and we got lots and lots of media coverage on this as well. So now that the bill has passed Parliament, has become an act and gone through Parliament, our focus is sort of slightly shifting away, because our focus has predominantly been on unfair dismissal so far, but now we are looking at SSP and really, I guess the phrase, doubling down on our ask on reintroducing a rebate for small businesses, which used to exist. It used to be that the government covered sick pay costs for small businesses, and it no longer is the case. So we are going to really emphasise that in the months ahead. As I said at the start, there's 70 measures in the Make Work Pay package altogether, so another 42 measures beyond the bill. And we really need the government to reconsider that, to be honest, because that's just too many. And the next point I just want to make is the Act itself is kind of what's known as a bit of a skeleton bill. So there's not really that much detail contained within the bill, but the detail related to the measures will mostly be addressed through secondary legislation. The one difference is that the unfair dismissal stuff within the bill, it was really important that we got a change to primary legislation there. But there is going to be, over the months ahead, lots and lots of different consultations, which I'll be responding to, particularly on 0 hours contracts is the most urgent one, where we're expecting a consultation in the next few weeks to be launched on that. So just to go through some of the consultations I've responded to quickly. So they have done one on fair pay agreement, so sectoral collective bargaining in adult social care, which we put in a pretty scathing response to, because we've recognised the large concern our members in adult social care have with that measure. And then, yeah, I'm not going to read all of these out, but just to say that we have been sort of really engaging with the detail, and we have been putting across our members' concerns on a huge range of issues. And there's going to be a lot more consultations this year as well that the government will be launching. So we've got one huge concession out of the government, but this is definitely not the end of our campaigning work, and there's still so much more to do. And really, as I said, please do get in touch and share any specific concerns or input you'd like to make into various future policy consultations. As I said, it's really helpful not just to get the data through from our surveys, but when you can talk about specific issues facing specific small businesses, civil servants and ministers always find that very interesting. So please do get in touch if you're able to, and please do make some noise about it as well if you're able to, either social media or directly to local MPs and politicians. That is always very useful. And thank you. I think I almost kept the time there, but I will stop it there.
Brilliant. Thank you, Chris. It's really clear the amount of work that you and the team have been doing on this, and thank you for that as well. So now we know what it is, I'm delighted to welcome Hannah Thomas to tell us what this means for you. Hannah qualified as a solicitor in 2007 and specialises in employment law, with a particular focus on providing guidance from a small business employer perspective. Alongside participating in webinars such as this and providing regular legal and content updates, she also creates and updates the employment law and health and safety content on the FSB Legal and Business Hub. Welcome, Hannah.
Yeah, thank you. Thank you, Emma, for that introduction. And Chris, it sounds like you and your team are going to be enormously busy responding to all those government consultations in the next year or so. So FSB member input is really valuable in responding to those consultations too. As Emma has introduced, I'm just going to talk you through in a bit more detail, focusing particularly on the upcoming changes that we expect this year in April. So that's not far away. So it's just over 2 months away, which isn't very far away at all. So just, I think just in particular, as Chris has mentioned, the Employment Rights Act, it's huge. I mean, it's a huge beast of a piece of legislation. As Chris mentioned, we expect there's going to be 30 changes to various existing areas of employment law. And the Employment Rights Act, just to emphasise, it does cover England, Wales and Scotland, and Northern Ireland will introduce its own employment rights bill in due course. So the key piece of legislation, which I do know has caused a lot of concern amongst employers, and particularly small business employers, was the initially proposed scrapping entirely of the qualifying period of unfair dismissal, making it a day one right. And I think we can all breathe a huge sigh of relief in the sense that what was being proposed initially under the bill was quite complicated, because we were going to have this kind of initial period of employment where there was going to be this lighter touch dismissal procedure that employers could use if they were going on to dismiss an employee. Just looking at it as from an employment law perspective, it was quite complicated. So although the new 6-month shortened qualifying period, it is short, it's still a reasonable amount of time if you are managing probation periods to get your ducks in a row and to follow a dismissal procedure. But yeah, I think the main thing that I could really take away as a silver lining from this is that what was originally proposed in the Employment Rights Bill in terms of the day one qualifying period obviously would have enormously increased the risk for employers, and also the complexity of carrying out a dismissal procedure. But just to emphasise that anyone that you have employed at this point in time, come the 1st of January next year, 1st of January 2027, they will all have unfair dismissal rights. So, for example, if you recruit someone on the 1st of July 2026, then by the 1st of January 2027, they will have unfair dismissal rights. So it's going to be particularly important to take legal advice and to carry out a fair process if you are dismissing coming up to the 1st of January 2027. And I just wanted to also just to quickly note, however, that currently, and this is not changing, that all employees do have certain protection from discrimination and certain automatically unfair dismissal rights from day one of their employment, and that is not changing. So just moving on in terms of what's on the horizon under the Employment Rights Act. So the changes are going to be introduced in 2 tranches, so in 2 waves. So we're looking at April this year and October this year. So April this year will see phase 1 of changes under the Act. And the huge change, Chris has mentioned obviously the impact in terms of concern, particularly for FSB members, will be the widening of eligibility for statutory sick pay for SSP in terms of the removal of the lower earnings limit for SSP eligibility. And also that all qualifying employees and workers will qualify for SSP from day one of their sickness absence. So currently there is a 3-day waiting period and you only be entitled to statutory sick pay from the 4th day of sickness absence. That's going to be a huge change. I'll come on to that. Also, we'll see the introduction in April of day one paternity leave rights and day one entitlement to unpaid parental leave. But I have to emphasise that there is no change to the 6th-month qualifying period for paternity pay. So because of this is not likely to be a huge change or hugely impactful for employers, but I will come on to it. April also sees the creation of the new Fair Work Agency and also the doubling of the Protective Award for failure to consult collectively when employers carry out large-scale redundancies. So just looking firstly at day one paternity and parental leave that we're going to see in April. So currently the situation is that eligible employees, so fathers or partners, are entitled to up to 2 weeks off to care for a new baby or newly adopted child. And the pay is typically at statutory rate. So most small businesses will pay statutory rates for paternity leave.
Hello.
And
Sorry to interrupt. Your slides just aren't moving on. I wondered if you could move them on for the participants. Would that be okay?
yeah, no, absolutely. Let me just,
Thank you.
yeah. So is that better, Emma?
Doesn't seem to be moving on for me. Could somebody in our back office see if it's moved on for them?
It's not moving on. No.
Same for me.
Okay, I think if we just continue, Hannah, because we'll be able to send the slides out
Yeah.
afterwards. Is that
No.
all right?
If you'd
Okay,
like
no,
to.
apologies. Apologies you can't see my slides because I appreciate it's quite a lot to take
That's
on.
okay. We'll be
I'll,
able to send it on.
Yeah, no, thank you, Emma. I'll continue talking through them.
Would you like me to share the slides for you? See if that works.
Yes, Beth, if
Yeah.
you could, I can.
Yeah. Fab. I will share the slides.
Thanks, Beth. Thanks, Hannah. Sorry.
Thank you. There, thank you. Thank you, Beth. Perfectly rescued. So hopefully you can all see my slides. So yeah, just to recap in terms of the day one paternity and parental leave entitlements that we're expecting from April. So the current position that eligible employees can take up to 2 weeks off for paternity leave to care for a new baby or newly adopted child. And this is most employers, business employers will pay this at the statutory rate. And the leave must be taken within the first year of the child's birth or placement. So the position now is that employees require 6 months employment service at the qualifying date in order to be entitled to paternity leave. What's changing from April this year is there will be a day one entitlement to take paternity leave. So from day one of your employment, you'll be entitled to take paternity leave if you qualify for it. But as I mentioned, there's still a 6-month employment service qualifying period in order to be entitled to statutory paternity leave pay. The second change in terms of these new day one rights will be a day one right to take unpaid parental leave. Now, unpaid parental leave allows employees to take up to 18 weeks unpaid time off per child for eligible employees, typically taken in blocks of weeks. I mean, the take up of this isn't particularly high because it is unpaid leave, but it's really just in terms of the government's commitment to introducing certain day one rights for certain entitlements, including these entitlements for parental leave. So just moving on, in terms of large-scale redundancies, I don't anticipate this will particularly affect too many small business employers, just because this only applies where you're carrying out large-scale redundancies in the workplace. And what I mean by large-scale redundancies, it means that if the employer is proposing to dismiss as redundant 20 or more employees within a 90-day period, then it has to go through a certain collective consultation with employee representatives. If the employer fails to do so or doesn't consult as per legal requirements, then the employee or the employee's representative on their behalf can bring a claim in the tribunal, and the penalties are high. So they could face a protective award of up to 90 days pay per employee in the case of a successful tribunal claim. From April 2026, this penalty, so this fine, would increase to 180 days pay, so that it would double. Just to briefly mention that. But just moving on, in terms of the Fair Work Agency, you may or may not have heard something about this new agency, this new enforcement agency, and this is going to be set up in April this year. And what this new Fair Work Agency will do, what their remit is, it's going to bring together the existing enforcement functions of HMRC, who currently enforces the national minimum wage, the Employment Agency Standards Inspectorate, who would enforce legislation as applies to employment agencies and employment businesses, i.e. businesses who recruit on behalf of employers, and also the Gang Masters and Labour Abuse Authority. So basically all the current disparate enforcement functions will come under one umbrella, under this new Fair Work Agency. But one point to mention is we don't know yet when the FWA's enforcement powers will be brought into force. So that's not to say that they're going to start going into workplaces come April, or those enforcement powers are going to be brought into force come April. But the Fair Work Agency will be set up in April. I do want to mention that the powers of enforcement officers are quite wide because they're going to have certain powers. So they can require individuals, for example, managers, directors of businesses, to attend meetings, answer certain questions, provide information or documents. And enforcement officers can actually attend the business premises to actually to inspect the employer's documents, access computers or other equipment. So it's a bit like the current powers of HMRC in terms of enforcing the national minimum wage. So I'll just go on to look a little bit more about the on the next slide in relation to some of the kind of enforcement powers and what the enforcement officers can do. So currently, most employment legislation is enforced by individuals. It's going to be individual employees or ex-employees by bringing claims in the employment tribunal. But what the new power the Fair Work Agency will have will be to bring certain employment tribunals in place of the worker, so on the worker's behalf. So that's going to be where the worker has the right in the first place to bring certain employment tribunal proceedings in England, Wales or Scotland. They can also do, so much like HMRC enforcement officers can do now, they're also going to have the power to issue notices of underpayment, so requiring the employer who's failed to pay certain statutory sums that are due to employees to make a payment within 28 days under a notice, and then very significantly plus a potential penalty. And the amount of penalty will be double the sum that is owed to the employee or ex-employee, and there's going to be capped at 20,000 per individual, and a minimum of £100 penalty would apply. And it's a bit like parking tickets in the sense that if the penalty is paid within a certain period of time, then that penalty reduces by half. But it's still very significant. And if the employer doesn't agree with the notice, then they can appeal to an employment tribunal within 28 days of the notice being served. So just to be aware, obviously, that does significantly increase the risk landscape from the employer, because we're looking at areas of law which aren't currently enforced other than the employee or ex-employee bringing a claim. So things such as statutory holiday pay, and we do know, particularly from speaking to members on the advice line, how complex it can be in terms of calculating statutory holiday pay for certain employees who don't work fixed hours or they have variable pay, and there are different calculation methods that may apply, and it can be quite complex. And it's an area, obviously, where employers are encouraged to take legal advice in order to get it right. And I think it will become even more so important to take legal advice in certain areas where the employer is unclear in terms of statutory entitlements, and also really important just to keep records, to keep payment records, so that if there is a challenge or if there is a query by the Fair Work Agency, once their enforcement powers in place, then the employer is in a position to be able to provide documents to prove that they have paid the correct payments if there is a dispute about that. So just moving on and looking at statutory sick pay. Now, this is the real big one, and Chris already mentioned that obviously a large proportion of respondents to the FSB survey are really concerned about statutory sick pay. And I do know from my colleagues who've spoken to members on the FSB legal advice line that they are concerned about kind of the financial implications of this, and have asked, what kind of support may be in place for small business employers in particular once this expansion of the statutory sick pay regime kicks in April 2026. So just want to explain exactly what's happening in April 2026 and what the employer's position is in relation to those changes. So currently, to be entitled to statutory sick pay, the worker, among other criteria, must be incapable of doing their work for 4 or more consecutive calendar days. So statutory sick pay is only paid from day 4 of the sickness absence currently. Also, workers have to earn a certain minimum level, so they must have average weekly earnings at or above the lower earnings limit, which is reviewed each year. It's currently £125 per week for the tax year ending in April this year. Another criterion which is not changing is that if their employer requires evidence that the employee is sick, then the employee is required to provide that evidence. So that's going to be usually when the employee is absent for the first 7 days of sickness absent, it's going to be themselves declaring in terms of their sickness. Once they've been off for 7 days or more, then for more than 7 days rather, then usually the employer is going to require them to provide a fit note, for example, from their GP. So what's changing in April and why is this such a big change? Well, in April, we will see the removal of this 3-day waiting period. So from day 1 of the sickness absent, the employee, subject to meeting all the other qualifying criteria, they are going to be entitled to receive statutory sick pay. So we're talking about those odd days of illness, so coughs, colds, stomach aches, etc., etc. Because currently the regime is designed to kind of discourage, in a sense, kind of taking time off for perhaps kind of the lower level sickness, or not requiring the employer to pay statutory sick pay for those kind of odd days of sickness. But this changes, so employees from April will be entitled to statutory sick pay from day 1 of their sickness absence. So that's very significant. That's going to be a very significant change. We're also going to see the removal of the lower earnings limit criterion for eligibility for statutory sick pay. So this means that all employees will qualify for statutory sick pay subject to meeting eligibility criteria regardless of their earnings. But what we're talking about is going to be kind of lower paid part-time workers, so workers who perhaps work 1 day a week typically, and they become sick, they will then become entitled to statutory sick pay, whereas currently they wouldn't be. So that's just to kind of set out the landscape in terms of what is changing from the 6th of April. We anticipated this is going to, it still requires regulations to bring this in, but we are all anticipating change is going to take place on the 6th of April this year. So just moving on and look at in a little bit more detail about what employers can do, because this is the question that we've been receiving on the advice line. Now, if an employee is sick and they're entitled to statutory sick pay, of course, then you need to pay it. Particularly, with the creation of the Fair Work Agency, it's going to be more important just to ensure that you're complying with statutory payment requirements, that you're keeping proper records. There is currently a statutory requirement to keep statutory sick pay records for up to 3 years at least for employees that you've paid statutory payments for. But that's going to become more important than ever, that you've kind of got evidence in terms of payments made and entitlements. So what can employers do? Well, unfortunately, kind of as Chris mentioned, FSB is continuing to lobby for the reintroduction of a rebate, particularly to help small business employers with the widening of the statutory sick pay scheme and the financial impact that it will have, undoubtedly, for employers. Since the rebate was abolished back in 2014 when it was abolished. So what can employers do? Well, our advice would be really the onus is going to be on the employer, I'm afraid, in terms of them being proactive in managing that sickness absence. And many employers may be doing it already, but I think it's going to become even more important. So how can you manage that sickness absence? So the starting point is going to be to really understand the root cause of any absence. So particularly if you've got employees with higher levels of absence, so it's going to be important just to talk to them and just to understand if there was any particular issues, because this is really going to help the employer or their line manager identify the appropriate response. So the most common causes could be that the employee is simply more vulnerable to catching viruses, colds and flu, and there's no particular underlying medical reason or condition, and in which case there's not an awful lot that the employer can do about that. And of course, employers will not want employees to come into the workplace if they are sick, or if they're not able to perform their job properly, and nobody wants that. But there are certain things that you can do in terms of identifying kind of root causes. So does the employee perhaps have an underlying medical condition? So perhaps they have lots of short-term absences, or perhaps there are longer-term absences. So it's going to be in question of investigating that with the employee in confidence. It may just be a question of setting up a 10-minute informal meeting just to speak to the employee, if they ask them if there's any additional support they want, any particular issues. And if there are, then the employer would want to go on and investigate that. If there is a potential underlying medical condition, then the employer would usually want to get the employee's written consent to approach their GP, or perhaps to obtain occupational health advice. And that's really going to be supporting the employee also, because what you want to do is, if possible, kind of reduce that absence, enable them to continue working where possible. It might be question of getting a medical advice or occupational health advice on workplace adjustments that could keep them working and reduce that level of absence. It might be that they're excessive tiredness, perhaps lifestyle reasons, perhaps even they have a second job if the employment contract permits that. Maybe they've also experienced some kind of personal, family, relationship problems, and it might be a question of certain things the employer can do to address that. For example, could they agree a period of unpaid leave? Perhaps that's not practicable. Maybe it is. Could they perhaps use their annual leave entitlement instead? So those are the sorts of issues. And it could just be kind of maybe they're problems of demotivation, workplace conflict, in which case you'd really want to address those underlying causes. For example, if the employee has a particular grievance, encouraging them to use a formal grievance procedure so you can properly address that, investigate those issues. Or maybe they're being a bit lazy, not performing satisfactorily, and you want to follow a performance management process. Or perhaps even it's a disciplinary matter, they're not just pulling their weight, in which case it's a conduct matter. So it's really important to have those conversations rather than just shy away from them. And you also have to remember that the impact that it has on the business if you have a lot of absence, and also on the team and other employees and so forth. So just moving on in terms of managing the sickness absence, I just want to mention that if you are an FSB member, that we do have quite a few templates and guidance in terms of administering statutory sick pay, and also managing sickness absence in terms of templates for return to work meetings. So if you are an FSB member, I'd really encourage you to have a look at those and kind of in the lead up to April and just think about kind of how you're going to kind of manage those sickness absences, because I think that would be our best advice in terms of that April change. Just want to kind of briefly mention also what's coming up in October 2026, because as I mentioned, October 26 we'll see like the second wave of changes. So we've got we're going to see a ban on firing and rehiring. So what this means essentially is where you are wanting to make significant changes to the employee's contracts of employment. You've tried to reach agreement on that, but the employee hasn't agreed. And these changes are very necessary for the business. So what some employers do, it's not so common among small business employers, I have to say, but what some particularly larger employers might do is they might want to force through that change. So they would dismiss the employee under their existing contract of employment, and they would offer them a new contract of employment with the new terms that you want to apply. And if the employer still disagrees or rejects that offer, then they are dismissed. This practice is going to be restricted, other than when the employer is the employer's kind of financial survival depends on them introducing these changes. So there are going to be restrictions around doing that in terms of introducing certain new terms that affect kind of pay, pension, shifts, working hours. I don't think it's going to be particularly impactful for most small business employers because, I mean, our experience, particularly on the employment advice, and it's not particularly a route because it is quite risky. It's not particularly a route that most small employers follow currently. The second one is a big change because currently there is a legal duty for employers in England, Scotland, and Wales to take a proactive stance, to proactively take reasonable measures to reduce the risk of sexual harassment in the workplace. This legal duty is going to be expanded in October. You may heard quite a lot of reports in the news about it. It's quite controversial in terms of it being expanded to apply not just to sexual harassment from colleagues, but also from third parties. By that I mean sexual harassment by customers, clients, contractors, so people that are not under the employer's control, who are not employed by the employer. So this is a widening of the employer's remit. There's also going to be a widening of that legal duty from taking reasonable measures to taking all reasonable measures to prevent sexual harassment, but not just sexual harassment, but harassment based on a protected characteristics such as racial harassment, sex-based harassment, etc. So it is a big change, and it's something that obviously we will be updating our guidance and templates on the FSB Legal and Business Hub leading up to that change, and you can expect more guidance around that from the government, etc. Another change is going to be currently most tribunal claims must be brought within 3 months, and there's going to be extension of that deadline from 3 months to 6 months, although it's not particularly clear how that's going to necessarily impact the employer because most claims are settled. So there could be a potentially longer period to settle claims, but at the same time, because you're widening the window in which claims can be brought, there may be more claims because there's a longer period in which to bring a claim. So it's a really kind of a wait and see how that one plays out. Very lastly, tipping. So for staff that accept tips from customers, there's going to be a new requirement to consult with representatives on tipping policies and some new trade union access rights. So I think that pretty much brings me to the end of kind of what I wanted to talk about today in terms of the upcoming changes. So yeah, I'll hand back to Emma.
Brilliant. Thank you, Hannah. That's great. And if we welcome Chris back as well, we've had lots and lots of questions, so I'm going to get through as many as possible. So let's just start. So firstly, we've had a number around 0 hours contracts. So we're a business that only employs part-time staff and are heavily reliant on 0 hours contract due to seasonal variations, which our staff understand are completely on board with. How can we mitigate running a business with the proposed changes to 0 hours contracts? And that was echoed by a question as well that said it talks about banning exploitative 0 hours contracts, but what about when it's mutually agreed or beneficial ones? So how can we answer that? Maybe Chris and then to you, Hannah?
Yeah, that sounds good. If I go first, and then Hannah maybe
perfect
the legal details. I think first of all, I think it is really confusing the language the government uses on this, because it sounds like they're banning 0 hours contracts outright, but they're not. You can still use them. It's just they're introducing those 3 measures that I mentioned. So an employee will have a right to a guaranteed hours contract after sort of consistently working for a certain amount of time on a 0 hours contract. Now, they haven't specified the amount of time someone has to be on a 0 hours contract before that comes in, and they haven't specified what consistently working means. And then the other 2 measures that I mentioned was a reasonable notice before a shift, and compensation if a shift is cancelled or changed. Again, so much of this is dependent on the details of those measures. And as I mentioned, the consultation, I was expecting consultation to come out by now, to be honest, but there must be a delay for some reason. And really, we'll be making a very strong case on on behalf of our members who employ people on 0 hours contracts, because the question's right, a lot of the time it is very mutually convenient for both parties. And I think trade unions often don't understand that when you look at the details and you look at the stats, it's often the case that the employee is perfectly happy to work on a sort of 0 hours contract because, I don't know, they might be a student, for instance, or they might have other commitments like that. So we absolutely will be making a very strong case on that. So I think hopefully Hannah will echo this, but the main thing is sort of don't panic right now, and let's see what the detail looks like, I would say.
Great. And from a employment law kind of context?
Yeah, I think I would echo what Chris advises in terms of kind of not panicking, because we are looking at 2027 for the introduction of the measures for 0 hour contracts and lower hour contracts. And as Chris mentioned, we don't yet have the regulations, so we don't yet know what that's going to look like. There are going to be certain exceptions for employers to the obligation to offer guaranteed hours. Don't quite yet know what those exceptions. For example, seasonal hour workers. And I think if that is the case, and it's going to be a question of the employer showing or keeping records of hours worked, just to show that there is a limited time. It's kind of for seasonal hour workers. But I think it's too early to kind of give concrete advice around it. But certainly I do think administratively it will be difficult in terms of running those contracts.
Okay, thank you. The next two are around menopause. So is there an update on the introduction of a menopause action plan for businesses included in the bill, which also goes to, is this, we know the menopause action plan affects businesses with greater than 250 employees. Do we know when it will trickle down to smaller than 250 employees? So Hannah, would you be able to answer this one?
Yeah, I think in terms of the timing for the kind of mandatory introduction of menopause action plans, I mean, obviously, as Emma, as you mentioned, it does only apply to large employers, so those with 250 or more employees, and we're expecting the introduction of that to be April 2027, although that's not set in stone. The government has said that it will publish advice or plans to publish advice for small businesses to introduce those on a voluntary basis, but I'm not aware that there are, and I doubt there are any plans to make that mandatory for small business employers. But small businesses can do so on a voluntary basis, for example, and it can help, obviously, if employers are aware of what supports is available, if they are experiencing menopause-related issues that impact on their work. And I just wanted to mention, if you are an FSB member, there is a menopause policy that you can access on the FSB Legal and Business Hub. So that could be a good starting point to have a look at that if you are thinking of introducing a policy or action plan on a voluntary basis as an employer.
Okay. We've had a lot of questions around statutory sick pay, so I'm going to try and group these together if that's okay. So bear with me. So what can employers do to mitigate the cost of statutory sick day coming in on day one? Is there scope to include an absence process that all sickness, regardless of the length, can be evidenced by a medical professional? Does statutory sick pay qualification, does it have a minimum age? And will there be changes to values on statutory sick pay so that staff that work less days per week currently receive a greater statutory sick pay? And one question is, somebody gives an enhanced sick pay, is that impacted as well? Sorry, there's lots on that, so I thought I'd group them together. Are you okay, Hannah, to take those? I can remind you halfway through if you've forgotten.
Yeah, no, thank you, Emma.
Thank you.
No, all really good questions. I think in terms of statutory sick pay, the government isn't planning at the moment to introduce a rebate. So in terms of direct financial assistance, there isn't any that's been proposed for small business employers. So there's nothing they can do to mitigate the financial impact of it, because because as with all statutory payments, once a worker qualifies for it, then it has to be paid. But I think it would come back to what I advised and mentioned around kind of being proactive in terms of managing sickness absence and kind of identifying root causes to sort of kind of help identify how that can be reduced. So you could just remind me that
Is there a minimum age, if there's a minimum age for statutory sick pay, and if somebody enhances the statutory sick pay, and also for the changes, can you confirm that day one it will still be a fit note, and then 7 days it will be a doctor's note?
Yeah, there's no changes to kind of the evidencing of the incapacity. So it's still going to be, the first 7 days, the employee rather, is not obliged to provide a doctor's note. If the employer wants the worker to provide medical evidence, then usually that's going to be a report. So usually there's no statutory obligation, but usually, obviously, the employer will pay for that report. Not aware of a minimum age for statutory sick pay, but not aware of any other changes around this statutory sick
That's
pay
great.
regime.
Thank you.
Yeah.
It is one of the biggest concerns for members, so thanks for answering all those questions. We've had a group as well around paternity and parental leave. So have the notice periods changed for paternity and unpaid parental leave, and around the transitional provisions for paternity and parental leave. So is the notice period reduced, but they're just reduced for employers who are coming into scope, so under 6 months of service? Should we reduce the notice period for taking this leave for everybody? Is the question. So are you okay, Hannah? Sorry.
Yeah, no, that's fine. That's good. Yeah, I'm not aware of any. Well, we haven't had regulations yet, of course, but I'm not aware of any kind of changes to notice period for actually taking paternity leave or unpaid parental leave. But of course, these changes are subject to regulations. So there have been, just because of the time factor, but there have been some changes around kind of bereaved partners, paternity leave. I didn't have time and scope within this session to cover it, but these have been kind of there are various changes that have been introduced, kind of which will affect kind of a narrower number of employees, but I'm not aware of any particular changes widely for paternity leave for a notice.
Okay, Chris, anything from you that you're aware of on that subject?
Well, I was actually just going to come back to the question on the waiting days and
Go for it.
notes. So this is something we did put to the government, that if you are removing the waiting days, then surely you should do a similar thing on requiring a fit note sooner than is currently the case. And we got pretty strong pushback that GPs wouldn't be up for that. But I do think it is pretty frustrating that they didn't hear us out on that, and I think it's something that we will continue to mention, because it doesn't really seem fair to me.
A question here, which I think we've answered, but when are regulations expected for April 2026 changes? Maybe Chris, you can answer that one.
It's pretty hard because they did publish an implementation timetable back in July last year, and they have massively slipped on said implementation timetable. So it's a little bit hard to predict. I mean, I would hope very soon, but honestly, I'm not too sure.
That's fine.
Unless Hannah has any other intel.
No, I think I'd echo that. Yeah, I'm not clear when regulations.
We've had some I'm just whizzing through these so that everyone gets an answer. So we've had some contract questions as well. So will probationary periods for new employees still be acceptable? If so, how long would you recommend? And do we need to reissue contracts for all employees?
Yeah, really strongly recommend. There's no legal requirement to incorporate a probation period with the contracts of employment, but really strongly recommend that employers do that, because then employees are aware that there is a probation period. Employers and line managers are aware too, so they can proactively manage those probation periods. And I think that's going to become more important than ever come January 2027 in terms of ensuring that you've had those performance discussions, and that if it's not working out and you're looking to dismiss, that you kind of do that kind of preferably before January, obviously, when unfair dismissal rights kick in. No requirement to issue new contracts of employment once these changes, or before or after these changes come in, because they will automatically apply anyway. They're statutory changes, they automatically apply, but you will need to update policy. So, for example, if your policy explicitly refers, for example, to the 3-day waiting period for statutory sick pay, then you will want to remove that reference to a 3-day waiting period for things like that. But obviously, we will update our own policies on the hub too.
Okay. You can see participants are thinking how this is going to work with them and their employees. We've had this question: hypothetically, if a worker has 3 part-time jobs and is sick for a week, are all employers then required to process sick pay? Very good question.
Yeah, that is quite a complex one, because it kind of depends on lots of factors. But I mean, potentially yes.
Okay.
If they all qualify from each employer, then potentially yes.
That's great, thank you. And then, does the 6-month qualifying period of service for unfair dismissal from January 27 include any notice periods?
Yes, it does. So it will be taken as the effective date of dismissal. So that will be at the end of the notice period, so include any notice period given. There is a slightly complicated rule about if you pay in lieu of notice, then you would add on a week for calculating their dismissal date for unfair dismissal purposes. But generally speaking, yes, it does include a notice period.
Okay, and I'm not too sure who's going to be best to answer this one, because it might be a dual answer. Are there any FSB recommendations on sickness monitoring systems such as Bradford system to use or manage sickness? I mean, I don't think we do, Chris, particularly recommend a system. I don't know if Hannah's got any thoughts on that.
I don't think we do. Unless Hannah has any thoughts.
Yeah, I don't. I mean, I know. I think particularly large employers do implement the Bradford factor. That is the most commonly used scheme in terms you get certain points for number of instances of sickness, and then kind of you take a particular process depending on kind of the Bradford points that have been accrued. I mean, personally speaking, I don't think it particularly matters what scheme. I think what is most important is kind of that proactive management and identifying patterns in terms of absence and speaking to employees. For me, personally, as someone advising, I think I would really be looking to see that employers kind of proactively manage whatever system they use. They proactively manage that absence, and they have that conversation with employees and carry out any necessary investigations.
Okay, brilliant. And then lastly, I'm very conscious of time. So one employer is worried about the measures that I have on young people. Is that included in the concerns that we're putting over to government, Chris?
Yeah, definitely. I think, I guess we haven't really spoken about the national living wage, which and the minimum wages for young people. But the government has committed to make the headline sort of national living wage, which is currently for people who are 21 and over, to go down to 18, and they're increasing the rates for young people because of that. And we've already seen it. There's an increase in young people out of work and out of training, out of education and training as well. And the government have commissioned a big review led by Alan Milburn, which...
So we definitely are.
Yeah, so it's definitely having a big impact. And I think the measures in the bill as well, I mean, when we did the survey, it was pretty conclusive that most small businesses are saying they'll look to hire people with more experience because of the increased regulation, and that's going to have an impact as well on young people. So it is really concerning. I think it's pretty devastating to most people to see sort of, I think it's about 1 million young people, so people under 25 out of work or education. It's not great.
Okay, brilliant. Thank you. And thank you for getting through as many questions as possible. And our time is literally up. I think I've got about 30 seconds. So thank you to everybody who's registered for the event today. You will receive an email with all the links and resources mentioned. We will be getting the content to you. It might not be in the slide form, but we will be getting the content to you. And you'll be able to watch the video on demand and go back and check some of those answers. If you've found it useful, please leave us a Trustpilot review, because your reviews help us to get out to more businesses. If you're interested in joining FSB, then drop us a line and let us know. As Hannah says, there's some great benefits that help you mitigate some of these risks. Thank you all very much, especially Chris and Hannah, for your time, and goodbye.